Good day to you, my friends. This is Eric McCool of Permagora Live, coming at you on July 4th, 2020, the 244th birthday of this republic. Now, a lot to be said about the American Republic that was and the empire that has already replaced it, but that's not what this is about. Today, I'm going to read you a book. It's a small, short book, but I found it this morning when I was looking for the Declaration of Independence, which I read to my children. And in short, all I'll say about the state of our nation is that I'm not celebrating the 4th of July because I believe that we are such a free country. Even though we're freer than a lot of countries, there's a lot of bad stuff that happened in our country's history. And in recent times, a lot of our liberties have been removed. But I'm celebrating Independence Day because I believe in independence. I believe in liberty, and I believe in the foundational principles that this nation was founded upon, regardless of whether or not they adhered to them over time. So, in celebration of the spirit of liberty and the spirit of defiance of tyranny, I'm going to read to you today from the Common Law Handbook. And this is a guide for jurors, sheriffs, bailiffs, and justices. And this is basically a constitutional handbook that helps people understand the nature of the law that is practiced in this country. Now, again, I'm not such a huge fan of the legal system, and I don't believe that it is the source of any legitimacy. I believe that rights and freedoms don't exist because the government says they do, but the government did get founded on the principle that it must honor these naturally occurring God-given rights. Now, this is a short book, but it's going to take a while to read it. I might do this in 2 parts. Just depends on how I feel and how long I can go. So, without further ado, I'm going to get started. It is the duty of jurors, sheriffs, bailiffs, and justices to resist all infringements upon the rights of the people without delay. Thomas Jefferson said, "Whenever people are well informed, they can be trusted with their own government." Clearly, the government cannot be in charge of deciding for themselves whether or not they should indict themselves on criminal charges. This is precisely why we have so much corruption in our government. I apologize. The quote ended. Jefferson said, "Whenever people are well informed, they can be trusted with their own government," end quote. And then it goes on to say that government can't be trusted to indict itself. This is precisely why we have so much corruption in our government. It is the duty of the people to stand up as the faithful and wise stewards, Luke 12:42, and bring the servants who think themselves master back into subjugation. Critical point there. The government, by definition, is an institution of service. We are their masters. They are not ours. They would like for us to forget that, and many people have. But common law is the idea that only natural law can be prosecuted in a court of law. Only natural law which is inherent to all creatures and is not just something written by a bunch of people in a courtroom or in a law office or wherever they write these things. I'll continue. Common law is common sense. The question each jurist must ask themselves is there an injured party? Is there a common law principle which states that for there to be a crime, there is a common law principle which states that for there to be a crime, there must first be a victim, corpus delicti. The state cannot be the injured party. In the absence of a victim, there can be no crime. This is what the grand jurist must discover. Quote, "The constitutions of most of our states assert that all power is inherent in the people, that they may exercise it by themselves in all cases to which they think themselves competent, as in electing their functionaries, executive, legislative, deciding by a jury of themselves both fact and law in all judiciary cases in which any fact is involved. Or they may ask by representatives freely and equally chosen that it is their right and duty to be at all times armed to freedom of person, freedom of religion, freedom of property, and freedom of the press," end quote. And that's from Thomas Jefferson in a letter to John Cartwright on June 5th, 1824. The Thomas Jefferson Papers in the Library of Congress. Grand Jurors 25. I'm not quite exactly sure what this is from. I suppose it'll tell us down here, but it's citing something. It says, "It is the duty of the common law grand jury to expose all fraud and corruption whenever it is in the political or judicial realm and stop it. The authority of the grand jury is found only in the Bill of Rights. Therefore, it comes from God and not government." Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. It is in effect a fourth branch of government, governed and administered to directly by and on behalf of the American people. Trial jurors, 12. The numbers are in brackets. I'm not sure exactly what again they're signifying, but it states, it is the duty of the jury to execute justice and sometimes mercy. Their decisions cannot be second-guessed. The jury shall have the right to determine the law and the fact. New York Constitution, Article 1. Another quote, as understood at common law and used in constitutional provision, jury imports a body of 12 men. Okay, so this is just giving us some definitions here of the jury and what jurors do. Jury nullification. This is a big issue for people who've been in the freedom movement for a while. We know about this. Many people do not know about this. The courts and the police do not want you to know about this, particularly when it pertains to drug laws and other victimless crimes. The jury has an unalienable right to judge both the law as well as the fact in controversy. John Jay, First Chief of Justice, United States Supreme Court, 1789. The jury has a right to determine both the law and the facts. Another Justice of the U.S. Supreme Court, Samuel Chase, 1796, who also signed the Declaration of Independence. The jury has the power to bring a verdict in the teeth of both law and fact. Oliver Wendell Holmes, Justice, U.S. Supreme Court, 1902. Central to the history of trial by jury is the right of jurors to vote not guilty if the law is unjust or unjustly applied. When jurors acquit a factually guilty defendant, we say that the jury nullified the law. The Founding Fathers believed that juries in criminal trials had a role to play as the conscience of the community and relied on juries nullifying to hold the government to the principles of the Constitution. Trust in the jury is, after all, one of the cornerstones of our, this is a quote, is one of the cornerstones of our entire criminal jurisprudence, and if that trust is without foundation, we must re-examine a great deal more than just the nullification doctrine. Judge David L. Bazelon. There may be no feature more distinctive of American legal culture than a criminal trial jury. Americans have a deep, stubborn devotion to the belief that the guilt or innocence of a person accused of a crime can only be judged fairly by a jury of his peers. This notion is particularly an American one, although it was inherited from English common law during the colonial era. Kentucky resolutions. A series of resolutions drawn up by Jefferson and adopted by the legislature of Kentucky in 1799 protested against the Alien and Sedition laws, declared their illegality, and announced the strict constructionist theory of the federal government, and declared nullification to be the rightful remedy. Justice. It is the duty of the justice to do justice. It's a tongue twister. In common law, the title justice is given in England to the judges of the King's Bench and the Common Pleas, and in America to the judges of the Supreme Court of the United States and of the appellate courts in many of the states. In the most extensive sense of the word, justice differs little from virtue, for it includes within itself the whole circle of virtues. Yet the common distinction between them is that which, considered positively and in itself, is called virtue, when considered relatively and with respect to others, has the name of justice. But justice, being in itself a part of virtue, is confined to the things simply good or evil, and consists in a man's taking such a proportion of them as he ought. Bouvier, it's apparently from whom that came. A source of virtue, found in Luke 6:19, and the whole multitude sought to touch him, for there went virtue out of him, and healed them all. References to the Bible, which I'm not going to speak on particularly at this point, although it is worth noting that almost all forms of government derive their legitimacy from the notion of God. And so whether you're an atheist or not, the government that rules over you is claiming that they have the right to do so because of God and because of their interpretation of God's law. So in the strictly legal sense, the Bible is a relevant document, regardless of what you believe about it theologically. Therefore, a justice is to reflect divine qualities, as we read in Philippians 4:8. Finally, brethren, whatsoever things are true, whatsoever things are honest, whatsoever things are just, whatsoever things are pure, whatsoever things are lovely, whatsoever things are of a good report, if there be any virtue, and if there be any praise, think on these things. Sheriff, top cop. America will never be destroyed from the outside. If we falter and lose our freedoms, it will be because we destroyed ourselves. Now, this is very important. That's Abraham Lincoln. Very important to realize that sheriffs are the law of the land, and their power in their jurisdiction is higher than that of the federal government. It's higher than that of the state government. It's higher than that of the UN and NATO, which is important to remember in times like these when such international organizations are, in fact, attempting to take over our policing force in this country. We need to support our sheriffs and make sure that they support us. And if not, we need to vote them out and bring in people who are going to uphold their oath to the Constitution. Sheriff, top cop. America will never... Oh, I said that already. Justice Scalia, writing in the majority in a 1997 decision, said that the states are not subject to federal direction, end quote, and that the U.S. Congress only had, quote, discrete and enumerated powers, end quote, and that federal impotency was, quote, rendered express, end quote, by the 10th Amendment. He confirmed that the sheriff is the chief law enforcement officer of the country, and also proclaimed that the states retained an inviolable sovereignty. Scalia went even further in this landmark decision, in which two small-town sheriffs headed by the feds, quote, headed off, this is awkwardly worded, I think, but in which two small-town sheriffs headed the feds off at the pass and sent them on their way. In other words, the feds told the sheriffs told the feds to hit the road because they weren't welcome there. And that's certainly within their rights to do so, as ruled by this guy. Scalia, in his infinite obligation to the Constitution, took this entire ruling to the 10th power when he said, quote, the Constitution protects us from our own best intentions so that we may resist the temptation to concentrate power in one location as an expedient solution to the crisis of the day, end quote. Obviously, the sheriff is the people's last line of defense against a government gone rogue. Boy, that hits home. Where are sheriffs at? The county sheriff is the last line of defense when it comes to upholding and defending the Constitution. The sheriff's duties and obligations go far beyond writing tickets, arresting criminals, and operating jails. The sheriff also has an obligation to protect the constitutional rights of the citizens in our counties. This includes the right to free speech, the right to assemble, and the right to bear arms. Remember the oath. Sheriffs took an oath to uphold and defend the Constitution from enemies foreign and domestic. In the history of our world, it is government tyranny that has violated the freedoms granted to us by our Creator more than any other. And it is the duty of the sheriff to protect their counties from those that would take away our freedoms, both foreign and domestic, whether it is a terrorist from Yemen or a bureaucrat from Washington, D.C. Bailiff. Officers who perform the duties of sheriffs within liberties or privileged jurisdictions in which formerly the king's writ could not be executed by the sheriff. One to whom some authority, care, guardianship, or jurisdiction is delivered, committed, or entrusted. One who is deputed or appointed to take charge of another's affairs, an overseer or superintendent, a keeper, protector, or guardian, a steward. A court attendant. It is the duty of all above to correct injustice inasmuch as it is in their power to do so. If correction is not possible, it is the duty of the court officers to report the problem to the protectors of the people, the grand jury, in whose hands justice has been entrusted. United States Codes, remedy of the people when rights violated. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby in anything the Constitution or laws of any state to the contrary notwithstanding. So that's a little tricky to understand, but I believe what it's saying is that The Constitution is the law to which all other things must yield. We all know that. That's kind of a cliche thing, but obviously it's not the case anymore because the Constitution has just been, disregarded right and left for the last many hundred years, or at least the last 100 years. Misprision of treason. USC 182382. Whoever having knowledge of treason conceals and does not make known the same to some judge is guilty of treason for contempt against the sovereign, and shall be fined under this title or imprisoned not more than 7 years, or both. Bribery. USC 18201. Bribery of any public official, directly or indirectly, gives, offers, or promises anything of value to any person or influence to influence any official act. Okay, so I don't know if I want to read all of this. This is basically outlining things like conspiracy against rights, deprivation of rights, concealment, clerkis to file. These are legal things. There's stuff further out in this document that I want to get to. I think I'm going to skip to this next chapter, which says, or not chapter, but heading, that's entitled Government by Consent. Our founders purposely placed the power of the grand jury in the Bill of Rights to make it clear that it belongs to the people, and the government is not to violate it. It is the ultimate power of the people which allows them to consent or not to the actions of their servant government. It also prevents government from unrighteous prosecutions by forcing the government to seek permission from the people before criminal charges can be filed. If the people refuse, it cannot go forward. By understanding this principle, it becomes clear that the government has no authority to control your behavior, and therefore neither do legislators without your consent. Very important point right here. The government has no authority to control your behavior, and neither do the legislators. So this is something that they have obviously all forgotten because they act as if we are their subjects and that they just issue the orders and we either follow them or we get the jail time. So you got to reconsider these things, my friends. This is very important stuff. These people work for us. Don't let them forget that. Or let's help them remember that since they seem to have forgotten it. The Declaration of Independence says, "We hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights, and among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed." Now that, I will say, is a little bit of an oxymoron, because the very word governance and govern implies the use of force. It implies the authority that's backed by violence. And so you can't really govern by consent as much as you can implement publicly decided upon policy, and only upon those who consent to have it implemented upon them. And as I was speaking earlier, I was reading where it said that they don't have the right to control your behavior. I would add something to that, which is to say, as long as you're not hurting anyone, or stealing, or committing a real crime according to natural law. So that means they don't have the right to tell you what you have to wear. They don't have the right to tell you where you can go or what you can say. But they do have the right to stop you if you're committing an actual crime with a victim. And so that's an important distinction, and I think that that's sort of implicit in this, but I want to make it really clear. All men decide whether they want to participate in the institutions of men or not. The United States Supreme Court confirmed this when they said, "Every man is independent of all laws except those prescribed by nature," which is the non-aggression principle, by the way, sometimes also called the Golden Rule. But it's more specifically, do no harm. Back to this. He is not bound by any institutions formed by his fellow man without his consent. Cruden versus Neal, 2 NC 338, May term 1796. There are only 3 ways a court can hear a criminal complaint. 1. One or more of the people sign a sworn affidavit that they have been injured. 2. A prosecutor on behalf of the government brings an accusation before the grand jury, and the grand jury either indicts or does nothing. 3. The grand jury, by its own will, can investigate merely on suspicion that the law is being violated, or even because it wants assurance that it is not. And if it finds wrongdoing, it can present it to the court and must go to a trial. No one can second-guess the grand jury unless the grand jury's actions violate another's unalienable rights. Consent and jurisdiction. It's all about consent and jurisdiction. In order to possess liberty, it is extremely important that you understand consent. our servant government cannot do anything without your consent. Somebody better tell them that. Any authority our servants have is by our consent. If they act outside their authority, they are subject to criminal charges under U.S. Codes 42 and 18 and are liable for damages under U.S. Codes and common law. The Fifth Amendment states, no person shall be held to answer for a capital or otherwise infamous crime. I've already read this. But I'm going to continue just because it's not long. Infamous crime unless on a presentment or indictment of grand jury. Therefore, our servant government requires the people to get an indictment, a grand jury. Judges, servant, have no authority to make a ruling or judgment on people, master, without your consent. In legal terms, when the judge asks, do you understand, he means, do you stand under the authority of this court? So when you say yes, you just gave him or her jurisdiction over you. Now, this is a very important point that many of the common law, sovereign citizen sorts of positions that I've heard elucidated in the past speak to. And they talk about, and they ask if you understand. It's best to say no, I do not understand. Another key term here is to say that you do not recognize. This is something I learned once from a guy who I don't know whatever happened to him. He's probably rotting in some hole somewhere for his good work exposing these crimes. But he was a great practitioner, I'll say, of putting the courts in their place. And he would go into courtrooms and he would basically nullify their jurisdiction by refusing to comply with their word games. And in particular, what stuck out to me from his message was the notion that when the court brings you into court, you need to ask for the cause of action. The cause of action means they can't even have a case about you unless there's a cause of action, which is an injured party. Therefore, you need to immediately ask, what's the cause of action? I would like to face my accuser. Who is accusing me of a crime? I need to speak to the person who is accusing me of a crime, or the living man who is accusing me of a crime, if you want to be more specific. Maybe it's a person, though. Maybe it's just a person in a mask, right? Someone with a fake identity that they're coming forward under. More of this legal stuff. But what I'm getting at here is that you need to ask to face your accuser, and if they say your accuser is the state or the county, the best way to deal with that is to say, I don't recognize the state. I don't recognize the county. Can you please produce them? Can you bring the county into the courtroom to accuse me directly? The county does not exist. The county is a fictional entity. So therefore, the county cannot be an aggrieved party. But by acknowledging the county as an entity, you are surrendering your right to be treated as a free human being. And you're surrendering jurisdiction of yourself into this, what is now essentially a maritime corporate law system. It's litigation law. It's a contract law. It's not natural common law. And the courts have been taken over, and they are now in the possession of these criminals who are using them to implement maritime law, or whatever you want to call it, right? Corporate law. So it's important to know these things, and that's why this handbook exists. It's to help people understand what their rights really are and how much power we really have if we would only but stand up and take it. Our Constitution only authorizes common law courts, also known as courts of record. A court of record removes the power of the judge to make a ruling. His role is that of administrator of the court. The final decision maker is the tribunal, who is either sovereign plaintiff or a jury. Remember, the servant cannot rule over the master. Can the clay rule over the potter? Quote, every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Cruden versus Neal. Herein is liberty. If you do not give the court consent, they have no jurisdiction over you. Under U.S. Codes 42 and 18, when you are detained without your consent for violating a statute, you have just been kidnapped. And if the judge sets a bail, he just set a ransom. And when the prosecutor confirms the charge, they are part of the conspiracy. And you can put them in jail and sue them for damages. It's all about consent and jurisdiction. Far too people don't know this. They are criminals. They are abducting people in the streets for no crime. It's not a crime to drive 5 miles an hour over the limit. It's not a crime to not pay for your registration. It's not a crime to have windows that are tinted too dark or to possess cannabis. None of these things are crimes. There are no victims. There is no crime. This is very plainly spelled out in the foundational documents of this nation. So the fact that people don't know these things and people have allowed this to happen is basically why it's happening. Because we, the people, have become too lax, and we are not putting these people who claim to rule over us in their place. The real law. The common law is the real law, the supreme law of the land. The code, the rules, the regulations, and policy are not, and statutes are not the law. Legislated statutes enforced upon the people in the name of law is a fraud. It has no authority and is without mercy. Justice without mercy is godless and therefore repugnant to our United States Constitution. Lawmakers were given the authority by the people to legislate codes, rules, and regulations and statutes, which are policies, procedures, and law to control the behavior of bureaucrats, elected and appointed officials, municipalities, and agencies, but were never given authority to control the behavior of the people. And as we read in a U.S. Supreme Court decision, all laws and rules and practices which are repugnant to the Constitution are null and void. And that is Marbury versus Madison, 5th U.S. 137, 174, 176, 1803. I assume 1803 is the year. I don't know exactly what all those other numbers represent, but Marbury versus Madison is a famous case. It's often quoted. All laws repugnant to the Constitution are null and void. This is how I've always lived my life. I look at a law and say, okay, is there a good reason for this law? And if there is, like, running red lights, I get it. Like, if it's middle of the night, no one's around, it's no big deal. I'm just going to go. Now, if it's a normal day and there's like people driving around, there's a reason for that law. Wait your turn. Don't go running through intersections. You're going to get someone hurt. So there's a reason for that law. And I feel like, okay, I'm good with that. But there's a lot of laws that have no basis in reason. They have no basis in justice. They're just regulations imposed by tyrants who are trying to tax me and everyone else. And those laws, forget about them. Break them as much as you can. I encourage that. Break unjust laws, just like Rosa Parks, just like all of the heroes of our stories that we think we hold up to, like even the founding of this nation. Those men were all breaking the law. Those men were all committing treason according to the king. But guess what? The king was wrong. And the government is wrong. They don't have a right to control your behavior. And they certainly aren't getting the right to control mine. I'll tell you that much. Legislators simply do not have the authority to rule make. Quote, where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Miranda versus Arizona, 384, U.S. 436, 491. God breaks down the law as follows. And Jesus answered him. And again, I'm not trying to this is what's in the book. I'm reading it. I'm not trying to make a Christian argument here. Again, we need to understand that the founding of this country was in the context of Christianity, with the Bible as sort of a held up high sort of authority, a document of authority. But to the people who don't like the Christian side of this, let me just say that there are some truths within that book that you might want to listen to and think about. And Jesus answered him, the first of all commandments is, hear, O Israel, the Lord is our God, or the Lord our God is one Lord. And thou shalt love the Lord thy God with all thy heart, and with all thy soul, and with all thy mind, and with all thy strength. And this is the first commandment. And the second is like, namely this, thou shalt love thy neighbor as thyself. There is no other commandment greater than these. And that's Mark 12, 29 through 31. And that is essentially the golden rule. That is the non-aggression principle. Let's not get into what loving our God means or how we're going to define God. Let's just say that loving your neighbor as yourself is essentially the notion that you don't hurt your neighbor, because you wouldn't do that. If you wouldn't want someone to do it to you, you can't go do it to them. Seems pretty basic and straightforward. Even kindergartners can get this. Although it is a sin, punishable only by the judge of the universe, to break the commandment to love in your mind, words, and deeds, it does not become a crime punishable by man until your words and deeds are expressed in actions that injure another. So that means sticks and stones, right? You can say whatever you want, you just can't use violence. Thomas Jefferson said, quote, I would rather be exposed to the inconveniences attending to too much liberty than those attending too small a degree of it, end quote. If one of the people exercises his free will to do such things as carry a weapon, travel, practice law, park without depositing money in a meter, use hemp, pharmaceuticals, alcohol, vitamins, minerals, or any other substance for medicinal or recreational purposes, legislators do not have the authority to impose upon people a fine, a license, or make such rights a crime. Period. They don't have the right. Rights and sovereignty. Only people are sovereign and have rights. Bureaucrats in their capacity are not sovereign and have no rights. They have authority given by the people and are subject to the statutes. The state cannot diminish the rights of the people. Hurtado versus People of the State of California, 110 U.S. 516. Quote, the assertion of federal rights, Bill of Rights, when plainly and reasonably made, is not to be defeated under the name of local practice. End quote. From Davis versus Weschler, 263 U.S. 22,24. Quote, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. End quote. Miranda versus Arizona, 384 U.S. 436, 491. Quote, there can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. That's Scherer versus Cullen, 481 F 946. Quote, sovereignty is itself, of course, not subject to law, for it is the author and source of law. Yickwo versus Hopkins, 118 U.S. 536, 370. To deprive the people of their sovereignty, it is first necessary to get the people to agree to submit to the authority of the entity they have created. That is done by getting them to claim they are citizens of that entity. See Constitution for the USA, and the 14th Amendment. And for the definition of a citizen of the United States. Okay, so then none of that was in quotes. That's a little confusing the way it was laid out here, but he was citing all of those cases, and then the author of this document finalized with that last statement. Licensing liberty. Quote, no state shall convert a liberty into a license and charge a fee thereof. Murdoch versus Pennsylvania, 319 U.S. 105. Quote, if the state converts a right or liberty into a privilege, the citizen can ignore the license and fee and engage in the right or liberty with impunity. That's important. And that comes from Shuttlesworth versus City of Birmingham, Alabama, 373 U.S. 262. A remedy for every injury. Every right, this is a quote, every right when withheld must have a remedy, and every injury its proper redress. William Blackstone. In the third volume of his commentaries, page 23, Blackstone states two cases in which a remedy is afforded by mere operation of law. In all other cases, he says, it is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law whenever that right is invaded, end quote. And afterwards, on page 109 of the same volume, he says, quote, I am next to consider such injuries as are cognizable by the courts of common law. And herein I shall for the present only remark that all possible injuries whatsoever that did not fall within the exclusive cognizance of either the ecclesiastical, military, or maritime tribunals are, for that reason, within the cognizance of the common law courts of justice. For it is a settled and invariable principle in the laws of England that every right, when withheld, must have a remedy, and every injury its proper redress. And that's 5 U.S. 137, Marbury versus Madison. Another quote, government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. Marbury versus Madison, 5 U.S. 137, 1803. Quote, that statutes which would deprive a citizen of the rights of a person or property without a regular trial according to the course and usage of common law would not be the law of the land. Hoke versus Henderson, 15, NC 15, 25, AM, DEC, DEC 677. I'm not quite sure what that stands for. Another quote, the right to be let alone, the most comprehensive of rights, and the right most valued by civilized men. To protect that right every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. Olmstead versus U.S. 277, U.S. 438, 478, 1928. Court. The court belongs to the sovereign. Plaintiff, parentheses, people, in parentheses. Black's Law Dictionary, 5th edition, page 318, defines the court as the person and suit of the sovereign, the place where the sovereign sojourns with his regal retinue, wherever that may be. End quote. In the U.S. Supreme Court case Isabel versus Stovall, the court was defined as an agency of the sovereign created by it directly or indirectly under its authority, consisting of one or more officers, established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying the sanctions of the law, authorized to exercise its powers in the court of law at times and places previously determined by lawful authority. End quote. I assume this is all still from Black's Law Dictionary. I don't know. It gave me a new quote in here. Oh, wait, I'm sorry. Yeah, that's Black's Law 4th edition. Or this is. Sorry, this is a little confusing, but just the way it's, all these quotes are stacked together and some of them aren't necessarily labeled. Quote, a judicial notice or knowledge upon which a judge is bound to act without having it proved in evidence. End quote, Black's Law 4th edition. Take judicial notice that judges are bound by oath to obey American Jurisprudence Book. Judges sworn to obey. Quote, since the Constitution is intended for the observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands or to counteract evasions thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom or the desirability of such provisions, and irrespective of the consequences. Thus, it is said the courts should be in our alert. The courts should be in our alert to enforce the provisions of the United States Constitution and guard against their infringement by legislative fiat or otherwise in accordance with the basic principles. The rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the delivered judgment of the tribunal before which the validity of the enactment is directly drawn into question. In other words, you've got to take it to a court if you're going to try and... There has to be a jury that decides these things, not so much that the legislators can just do it and then all of us have to follow it. And so again, this made it a point earlier that the legislators are making laws not that pertain to us, but that pertain to elected officials, bureaucrats, and in some cases, corporations, bodies of people who aren't really people, right? That's what limited liability is all about. But of course, all of that's been corrupted, and now the corporations have more power and more standing under law than the citizens do. But according to the way it was supposed to be laid out, that's not the case. I think I stopped in the middle of this quote. If the Constitution prescribes one rule and the statute another in a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment. 16 AM, GAUR 2D, section 155. I'm not super educated in law, I'll be honest. I know in general how these things work. I've studied the sort of counter narrative of law, the people who have been examining law for what it really is, but I haven't studied that stuff well enough to know it inside and out. But I felt like I need to, because I know in my heart who makes the rules, and it isn't them. And I know how much power they have to enforce, and I know that ultimately they don't have the power, and it's only because people are so insouciant and so gullible that they get away with everything they get away with. As soon as the people get informed, the game's over for these tyrants. The law of the land, quote, the Constitution, this Constitution, and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, are under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of the state to the contrary notwithstanding. We already read that. Quote, thus the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. After more than 200 years, this decision still stands. Oh, I'm sorry, that was end quote. After 200 more years, this decision still stands. Marbury versus Madison, 5 U.S. 137, 1803. Reading all this constitutional stuff, I'd like to stop for a minute and make a distinction here. A lot of my libertarian and voluntarist friends are not happy about all of these constitutional people saying, my constitution, and I get it. Like, I can laugh at that too, because clearly the thing's been scrapped. And I'm not reading this as if to like hold this constitution up and say this is the ultimate authority and truth. However, the people who are implementing the laws that are governing our lives, and in some cases ruining our lives, are basing all of their authority on this constitution. And so whether or not we agree with it or think that it's legitimate, we have to understand that the powers that run the world, or at least that run this country, are deriving their authority from this document. And this is the foundation of their entire philosophy and their entire existence. And so we need to study it, we need to understand what it is and what it really means, and we need to take the power of their interpretation of it back, because ultimately it was designed to protect us from them. I've read Lysander Spooner, who is probably the only time I've ever read anything that mentions the word Constitution more than this little book, but in the opposite sense. He's like disparaging of it and talking about, don't come to me with your constitutions. It's like, Constitution can't do squat for you. And he's right, but I'm reading this because, you know, this is the Independence Day. This is the day when our country became an idea that would stand into the future for who knows however long. But I feel like it's important for us to either abolish this government altogether or get it back in line to what it was designed to be. And either one of those things would, assuming that in the former case that we had an alternative voluntarist management of the commons and management of the policies governing the use of force, because I mean, there still needs to be some semblance. People think some semblance of justice, right? People think that anarchists and voluntarists just want a chaotic world where there's no law and where there's no rules, but anarchy means no rulers, not no rules. The rules are obvious, do no harm. And the only justifiable use of law or force of law is when there is demonstrable harm being done and there's a victim willing to stand up and say, yeah, I'm the victim and I'll name the perpetrators. So we aren't advocating that we get rid of all of these systems of law, but we do need to rewrite the whole thing. And as the Declaration of Independence states, it's our right to alter or abolish the government. And I think it's pretty much time to do that, my friends. Okay, so I'm going to skip some of these cases because I think we get the point that they say over and over and over again that no legislation can deprive the citizens of rights. Like, that's stated in so many Supreme Court cases. And then there's interpretation. Any constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. Quote, then a constitution should receive a literal interpretation in favor of the citizen. Is especially true when, with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to a person and property. And that's from a really long case that I'm not going to read all the little details on anymore, but it's Berry versus United States. Now, this is a line that's particularly relevant in these times. No emergency has just cause to suppress the Constitution. You hear that, governors? Your emergency declarations are horseshit. No emergency gives you the right to take away our freedoms. Quote, while an emergency cannot create power, and no emergency justifies the violation of any kind of the provisions of the United States Constitution or state constitutions. I guess this is law language. That sounds like a, dangling sentence there, but they're just saying that emergencies cannot create the power and no emergency justifies the violation of our rights. Continuing. Public emergency such as economic depression for especially liberal construction of constitutional powers, and it has been declared that because of national emergency, it is the policy of the courts in times of national peril so liberally to construe the special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and that end also more liberally to construe the constituted division and classification of the powers of the coordinate branches of the government, and insofar as may not be clearly inconsistent with the Constitution. That is a terribly written sentence. That's from this 16 AM JUR 2D section 98. I'm not even sure what that's from, but I think what they're getting at there is that what I just said. I don't care what emergency there is. You don't get to take away the Constitution, period. Constitutions must be construed to reference the common law. This might be another one of those, but let's go with it. Quote, as to the construction with reference to common law, an important canon of construction is that constitutions must be construed to reference the common law. Speaking in circles here. The common law so permitted destruction of the abatement of nuisances by summary proceedings, and it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in the sense of a national customary law, as distinguished from the common law of England, adopted in several states, in interpreting the federal constitution, recourse may still be had to aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution cannot be understood. I think the language of this quote can't be really well understood, but I'm going to go back and read this again and make sure I got it right. But for this video, I'm just going to move ahead. Okay. Pardon me for just a second. I'm trying to see if this is worth reading. Conflicts. Quote, in all instances where the court exercises its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. Thus, the statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. A clear incompatibility between law and the Constitution must exist before the judiciary is justified in holding the law unconstitutional. This principle is, of course, in line with the rule that doubts as the constitutionality should be resolved in the favor of constitutionality and the beneficiary. I think that's just saying we're erring on the side of caution and that we're not going to let the courts, we shouldn't let the courts take away your freedoms. Maybe I'm misinterpreting here, but this is the next one, basis of all law. Nisi prius courts rely on statutes, which is fiction of law, which seeks to control the behavior of the sovereign people who are under common law and not statutes, and who are ordained and established, and who ordained and established the law. Therefore, legislators cannot legislate the behavior of the people. This isn't a quote, by the way. That was just the writer. And now we have quote, no one is bound. No provision of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come into conflict with the supreme law was illogical, for certainly the supreme law would prevail over all others, and certainly our forefathers had intended that the supreme law would be the basis of all law, and for any law to come in conflict would be null and void of law. It would bear no power to enforce, it would bear no obligation to obey, it would purport to settle as if it had never existed, for in unconstitutionality would date from the enactment of such law, not from the date which so branded it in an open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as a clear nullity or a fiction of law. The general rule is that an unconstitutional statute, I should say, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since the unconstitutionality dates from the time of its enactment. I think they said that already. We'll go ahead and skip some. Such a statute lives a question that it purports to settle, just as it would be had the statute not ever been enacted. No repeal of an enactment is necessary, since an unconstitutional law is void. The general principles follows that it imposes no duty, confers no rights, creates no office, bestows no power of authority on anyone, affords no protection, and justifies no acts performed under it. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Okay, I'm not going to continue with all this because I think we get the point. This is also from the 16 AM JUR 2D section 256. I need to figure out what that is. I'm sure it's some sort of legal publication that came out. Congress cannot alter rights. On the other hand, it is clear that the Congress cannot, by authorization or ratification, give the slightest effect to a law or constitution which is in conflict with the Constitution of the United States. Same thing, section 258. Rights do not come in degrees. And I don't think I'm going to read all of this language. I think I'm trying to move through this a little faster. I'm about halfway through the book. I'm going to have to stop soon and do another section later, but I'm going to move ahead a little bit and get to some parts where I feel like it's going to be more in point with what I'm trying to talk about here. Okay, this is interesting. This says government. We the people are a republic, not a democracy, which is just the first step to an oligarchy. That's an interesting quote. Democracy is the first step to an oligarchy. And we've seen that we've taken more than just the first step in this case. Republican, one in which the powers of sovereignty are vested in the people and exercised by the people, either directly or through representatives chosen by the people, to whom those powers are specially delegated. In Re Duncan, 139 U.S. 449. Lots of stuff. I'm not going to read it all. Minor versus Happersett, 88 U.S. A whole bunch more. And Black's Law definition. I guess this is citing a bunch of different stuff together. Democracy. That form of government in which the sovereign power resides in and is exercised by the whole body of free citizens, directly or indirectly through a system of representation, as distinguished from a monarchy, aristocracy, or oligarchy. And that's Black's Law, 5th edition, page 388. Also, Bond versus U.S. Supreme Court of the United States recognizes personal sovereignty, June 16th, 2011. I'm skipping again. This is all quotes from these cases, which I may come back tomorrow and read more and read some of this stuff, but right now I feel like there's something further back towards the end that I really wanted to read. I am, by this point, skipping towards the end. I might just get through this whole thing and cherry pick some more good stuff out of this. I mean, I feel like I've made emphasis on the points that I really wanted to already, and this has backed it up with plenty of cases. But let's read Thomas Jefferson here. He's got a few quotes. Only the people can save America is the headline of this little section. I know, quote, I know no safe depository of the ultimate powers of the society, but the people themselves, I'm sorry, that's all one sentence, but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion by education. This is the true corrective of abuses of constitutional power. Big statement right there. You don't just say, oh, you people aren't able to handle being free. You aren't able to handle all this. We'll just make the laws for you. And it's very, very patronizing, very much, infantilizing us. As if to say, like, we can't handle it ourselves, so mommy's going to do it for you. You educate people. If they don't understand well enough to be free, then teach them. Don't just lock them up in cages because they just can't do it. This is fundamental to psychology and to child raising and to all these things in which it's on the authority, it's on the leader, it's on the parent, it's on the person in power to bring everyone else up to their level, not to keep everyone down so that they can enjoy power while everyone else suffers in ignorance. That's just me, though. Thomas Jefferson again, quote, educate and inform the whole mass of people. They are the only sure reliance for the preservation of our liberty. So if too many people, if enough people aren't educated and free, then none of us are going to be. And we're seeing that now. We're seeing it with all the people complying with all of these completely unconstitutional, unjust laws being foisted upon us by these criminal colluders with global fascist planners, right? Like, this is a criminal collusion that people are going along with, and their ignorance is leading us all to the death camps, or at least anyone who's dumb enough to get on the train car. I say, make your stand before that point, people. Quote, an enlightened citizenry is indispensable for the proper functioning of a republic. Self-government is not possible unless the citizens are educated sufficiently to enable them to exercise oversight. It is therefore imperative that the nation see to it that a suitable education be provided for all its citizens. It should be noted this is weird, because this is a quote by Thomas Jefferson, and it mentions him. So I'm going to just read it as it's written. It should be noted that when Jefferson speaks of science, he is often referring to knowledge or learning in general. Maybe he's speaking of himself in the third person, I don't know. Another quote. If a nation expects to be ignorant and free in a state of civilization, it expects what was never and never will be. In other words, if you're trying to stay ignorant, you're not going to be free. This lists the duties of the grand jurors, the jurist's oath. Okay, so here's some more of the author himself saying, think about this. If we the people can reinstate justice and demand that elected officials and bureaucrats obey the law or be indicted, we would have succeeded in reinstating the Constitution. Only the people can stand up and defend the Constitution, because the Constitution cannot defend itself, and the bureaucrats will never do it. Good point right there. Declaration. A little bit more. Lots of quotes here at the end. I think I'm going to just wrap it up by reading a few of these and see which ones are good. Trying to find the ones that are most pertinent here. Quote, the favorable smiles of heaven can never be expected on a nation that disregards the eternal rules of order and right, in which heaven has itself ordained. That's George Washington. Quote, God who gave us life gave us liberty. And can the liberties of a nation be thought secure when we have removed their only firm basis, a conviction in the minds of people that these liberties are a gift of God, that they are not to be violated, but with his wrath? Indeed, I tremble for my country when I reflect that God is just and that his justice cannot sleep forever. I'm not quite sure how to interpret that. I think he's saying that, people aren't following the laws of God, and therefore, eventually that's going to catch up to them. I'm not sure. This is a lot of talking about God, which I spoke on a minute ago. Like, that's not necessarily where I'm coming at it from, although I think there's some legitimacy to it. Call it God, call it the universe, call it nature, call it whatever you want. Something created us. We didn't create ourselves. The government didn't create us. We came from somewhere. And whatever the source of all of this is, this physical reality we live in, we can see laws inherent to it, and we can understand the basic principles of how things work. That's what science was so good at discovering in the early days of modern science, was learning the laws of nature and the laws of mathematics. And so if you don't like the religious thing and you don't want to be affiliated with that, just look at it like this. The forces of creation, whatever those may be, are the source of our freedom and our rights. The sources of creation gave you free will. They gave you hands and a mouth and feet to do what you will. They didn't govern you with limitations. Those limitations were artificially imposed upon you by people pretending to be the law, pretending to be your rulers. But you do not have rulers unless you consent to it, unless you surrender to them and decide, I guess I'm just going to do what these people say. And you could say that that's what happens when you join the military or decide to work for a company. You basically are agreeing to follow their rules, because you're getting something from them and they're asking something of you in return. Contract law is a real thing. It just doesn't govern people's regular behavior. If I haven't signed a contract with you, you don't have any power to tell me what to do. Period. So, that is that. I'm not going to read the rest of these because I think they're all religious, and I assume that the author of this is religious, which is fine. In fact, I found a lot of religious people are the strongest voices in the current, I would say, renaissance of liberty. There's a lot of people who have not been happy about the government's overreach in the last several months, and most of them, I find, are conservative religious people, which I don't particularly agree with all of their positions. I don't consider myself to be any of those things, but guess what? I don't care. I don't care what your orientation is. If you're standing up for liberty, I'm standing with you. If you're trying to tell me what I've got to do and trying to tell me what I can't do and trying to govern my life, you're going to be on the wrong side of this thing, and I'm not going to be nice. I'm not going to pretend as if you have the right to do that, and if you get in my face too much, we're going to have a problem. I understand? Like, I'm not trying to be all bombastic here, but like, this is serious stuff. Like, our rights are getting trampled right now, and we got to stand up and say no. And I will, I am, and I will always. So I hope that people out there will take inspiration and will get some courage, because without courage, we cannot win this war. We are at war. This is a war. This is the Third World War, and it's being fought inside of our heads, and it's being fought in the internet with information, and it's being fought out there in the streets with policies that will either be followed or not. So don't follow policies without doing some research first and learning the reason for them, learning who the authors of them are, learning who their affiliates are and why they might be making these rules up. Be a little suspicious. Be suspicious of new rules that suddenly come around and now everyone's just supposed to accept that this is the new normal. Be very suspicious of that, because this is social engineering, and those of you who have done any kind of research into these things, into the history of propaganda, into the history of eugenics, into the history of the notion of one world government, you should know better. Those of you who haven't done your reading, well, then you should do your reading. And don't try and tell me I'm just a kooky conspiracy theorist if you haven't even read the facts of history. So, with that, I shall leave it. I'm not going to read the rest of this. I think I got out of it most of what I wanted to. And I hope that everyone will get hold of books like this that explain to you what your rights really are and explain to you the real way that this government is supposed to function. And if we have to abolish it, that's fine, as long as we replace it with something that is actually going to be accountable and transparent, which is possible. We got blockchain, we got the internet, we could do a lot. But, you know, if we're not going to abolish it, then we should pretty much gut it and remodel it completely. So hopefully these events of this year will push enough people to the brink to where we're all ready for a mass uprising and a mass movement to do these things. I encourage all of you to do your very best, to live honorably, to stand your ground, to consider others, and to not be selfish and rude and thinking that, oh, my freedoms, I'll just stomp all over everyone else. That's not what it's about. Respect people, but don't let them boss you around. Don't let them tell you what to do. That's all for now. Love you guys. Take care.